Good afternoon, everybody. Thank you for joining us. My name is Jamie Dreyer. I've participated in quite a few of our recent seminar series presentations. I'm a partner in the Corporate Financial Restructuring, Commercial Law, and Bankruptcy Group at Downey Brand. I'm going to moderate a little bit, really just kind of introduce our panelists for today. So let me talk about the agenda just very briefly. To start, Scott Shapiro is going to talk about things of interest, I think, to everybody, which include preparing for returning to work and what policies and implications and what types of approaches that might require. Cass Farinini is then going to give an employment update in what is an ever-changing field. Kristen Caprito is going to give some estate planning tips, an update on current estate planning issues, and the like, and an overview and a little bit of background about how the current environment has affected those issues. Lastly, I'm going to talk a little bit about loan workout issues and approaches, mostly from a borrower perspective, having looked at the attendance list, and a little bit of a background on what bankruptcy is, what it can and can't do, whether it might help you, some brief background. So that's the agenda. Please, everybody, make sure that your phone or computer is on mute. We think we have everybody muted on our end, but just to be safe, it makes for a nice, clear sound. You should note that we are recording this. This is the 7th in our, we have been calling them the COVID-19 seminars. I'm going to make a pitch right here for anybody to suggest a different name. I mean, frankly, COVID-19 is, you know, yeah, and it overarches everything we're doing. And I think we're getting a little bit tired of the title. So any suggestions are welcome. We are going to continue to give this webinar series. This is, I think, our 7th one since March, and recordings and some presentation materials are on our website at www.downeybrand.com. If you have questions during the webinar, feel free to post them. We'll be monitoring them. Are going to save some time at the end to try to address some if possible. Additionally, you know, during the presentation, we may jump in. I'm going to try to monitor them, and we might throw some questions to panelists if they come up. There's a blue chat box on your screen. Click that, type in your question, hit enter. That should do it. Finally, slight disclaimer here, which is to the extent those on the phone are not clients, we're not offering here with legal advice that you can rely on because everybody's situation is different. All that said, we hope that what we're providing is helpful to you. We're going to talk about some things general, some things specific. So hope you get something out of it. And with that, I'm going to turn things over to Scott Shapiro.
Well, good afternoon, everybody. Thanks for joining us today. As Jamie indicated, my name is Scott Shapiro. I'm the managing partner at Downey Brand. I practice in the area of water and flood protection. And one might wonder what a lawyer who practices in the area of water and flood protection has to do with a topic which is preparing for the return to work. And I bring two perspectives to this topic. The first is, as many of my clients are public agencies that are out in the environment doing work right now to ensure that we have water when you turn the faucets on, or that we are not flooded if the rains ever started up again, and they are struggling with these issues. But also, as managing partner, which I've now been in my 7th year, I have to think about these issues for our 170 people that are at Downey Brand. And so what I want to do is bring some of those perspectives to you today. Some of what I'm going to talk about is unfortunately somewhat generic due to the fact that there are so many rules and they apply to so many industries in different ways. But I do think I'm going to be able to provide a framework to you, and that framework will be helpful not only as you consider your own situation, but then as you listen to the presentation that Cass Farinini is going to do, which will start to get into more specificity on some of the employee-employer relationship issues that arise out of the context we're in. So I want to start by noting that the slide is interesting in that it's entitled Preparing for the Return to Work. And you can view that figuratively or literally. Many of us are working. We're just doing so in non-traditional environments. I'm on my patio right now. Hopefully the dogs will stay away and the kids won't come running by. And probably many of you are in a similar situation where you're having to work in a non-traditional environment. And so you're already working. The question we're really asking is more about the physical return to work, about coming back into a place together. And what I want you to think about, and hopefully you are already thinking about, is the tension that exists between staying remote and coming back. Now, if you're a business where you can only operate in physical proximity to others, let's imagine you're a restaurant and you can't do takeout business, or let's imagine you're a manufacturing facility and there's nothing to do from home, then this is a different question for you. And really, we're going to talk a little bit about those situations as well. But if you're like many businesses in the Sacramento region where some functionality can occur when you're working from home, the tension is between pushing people to come back sooner or staying at home. And that tension is important because on the one side, you have the very likely scenario that people's productivity is higher when they're in the office. If you're like me, you have family members at home, the doorbell rings, Amazon packages are being dropped off, and it can be distracting as to how much work you can get done in a particular day. And that would suggest that coming back sooner is better because as a business, we need to continue to operate, we need revenue to flow, we need work to be done, and that happens if we're more productive. The other side of the tension formula, though, are what happens if you come back in too soon or in a way that ends up creating problems. On the one hand, obviously, what you want to do is you want to keep your people healthy. Secondly, you want to not create a situation in which coming back can create liability for your business. And Cass will talk about some of the presumptions that are in place now in the workers' compensation area and how those presumptions can actually create the potential for liability. But in addition to keeping people healthy and keeping people from suing you and having liability, there's also a third factor that I wanted to point out, and that's to avoid the impact of an infection in your office. And if an infection does come into your office, and if you haven't put in place the proper protections, then what you can end up with is a node or a nucleus of infection within your office, meaning any number of people in your office or in your facility can have it. And not only do you have the liability issues and the health issues, you also have a forced loss of productivity as you shut the place down to clean it, as you have people who then go into a quarantine mode for a period of time, as those people who are sick and are under the weather are not able to be productive for the business. So as a general matter, if you can operate from home and operating from home is not killing productivity, that's something to continue to do for a period of time. And that would really be consistent with Governor Newsom's 4-stage approach. We're in stage 1, we're moving to stage 2. Stage 2 allows more businesses to open, it allows retail to open with curbside delivery. But importantly, if you read through that stage 2, for people who can work at home, it really encourages that continued teleworking environment. And it's not until we get to stage 3 that the governor's plan has people coming back into that work environment. So that is something that I would encourage you to think about. In terms of what are the various orders and authorities, there are a number of binding ones, and then there are a number of guidance documents. The governor's order is out there. It is mandatory, although as you read from newspaper articles, that doesn't mean the counties agree, and it doesn't mean anyone's enforcing it. And there are many businesses that are ignoring it at this point. There are also county orders. And while originally there was a lot of symmetry or parallel in the various county orders, that symmetry is dissipating. For example, in the Bay Area, we have county orders that remain much more strict. And then we have county orders in Yuba and Sutter counties in our region, which have become more liberal. Those county orders take a different approach than the governor's order does. Which is binding? Well, they're both binding. And the more restrictive one is the one to pay attention to. But the consequences of not paying attention to it or that risk calculation are what businesses need to think about. Obviously, as attorneys, we are here to advise you on how to minimize your liability and minimize violating the law. And then as businesses or organizations, you apply business judgment to determine what that risk is and what the consequence of that risk would be for your business. I'll talk for just a second about the different formulas that are being used in some of the different orders. Generally, most of the orders that have been in place, the Sacramento County order that's still in place, the Bay Area orders that are in place, they follow the governor's distinction of, are you an essential business in a critical area? And if you are, then you stay open and you follow social distancing rules. And if you're not, you close or you operate from home. The Yuba and Sutter County order is different in that it looks at a risk approach and it categorizes different types of businesses into a low, a medium, or a high risk. And it does so by looking at some different factors. Some of the factors that it looks at are what are the quantity of people that you might interact with? Another factor that it looks at is what is the proximity that people will have to each other in that particular environment? Very early on in the COVID-19 environment, there was a study that the New York Times put out, and it was based on some OSHA data. And it was a very simple graph. On the y-axis, the vertical axis, it talked about what are the number of people that particular careers interact with. And on the x-axis, the horizontal axis, it talked about what is the physical proximity to people that you have in your particular career. And what I noted is that lawyers was very low on the y and x axis. We don't interact with a lot of people during the day. We don't have a tremendous physical proximity to them. At the other end of the spectrum are dentists. Dentists will see 20, 30 patients a day, and they're right in their face during the day. And so based on that, there's a much higher risk for dentists and a much lower risk for attorneys. And based on that kind of approach, Yuba and Sutter counties have said, well, what are the relative risks in different areas? And it is saying if you're a business or an activity that is a low or medium risk, and you do proper precautions, you do face masks, you maintain social distancing, you do disinfectant work, then those are businesses that can open. And if you're at the high end, then even with those things, you should not be open unless you're an essential business. So those different approaches exist. And for those of you that operate in multiple counties, this can be a very complicating thing. And it's important that you review both the state orders as well as the relevant county orders. Beyond the orders which are mandatory, you also need to look at the various guidance documents that are out there. And Cass Fernini, for example, is going to talk about the governor's OSHA guidance, which just came out yesterday, and what it does in terms of laying out guidance for employers and how to proceed. I wanted to talk a little bit about the language it uses about face masks. It doesn't order face masks. It doesn't say they shall be used. It does, however, say that we need to be using all available methods, and it calls face masks a key method. So what you have is very, very strong guidance, which is not mandatory, but failure to follow that strong guidance, if there's a problem, as Cass will talk to you about, can create some issues for you as a business. So we've talked about this issue of essential. We've talked about the possibility of people continuing to telework. We've also talked about the high, medium, and low risk categories that are being used by some of the counties and what the different orders and guidance are. What I also wanted to do was talk a little bit about a plan. And here I might be speaking a little bit less as a lawyer and a little bit more as a CEO of an organization in helping you think about some of the things that you should be thinking about as you're going forward. I think it's important that you have a plan. And separate from the legal issues that Cass will talk about for the various different kinds of plans you have to have, I think right now, the key is to remember that what you're going to do in the next week or 2 or 3 weeks is going to set the stage for a period that may last a year at this point. And so getting it right up front, providing clear guidance to your employees, creating a clear chain of authority on who's going to make decisions is really going to be essential for your operation. A lot of what we do as business leaders is think about the psychology of how our organizations run. And we have to recognize that over time, ever-changing environments are difficult for our employees. They're difficult on a human level, they're difficult on a production level. And to the extent that we set rules now and we change them in 2 weeks and we change them 2 weeks after that, it creates confusion, it creates dissension, and frankly, it undermines and undercuts any authority we have as business leaders. So better to take a little bit more time and get it right before coming out with something too quickly. One example that I've been dealing with is I reached out to our office services manager, who's very diligent. And I said, well, what's our disinfectant plan right now? And as you might expect, we have a written disinfectant plan. And it talks about these are the areas that will be cleaned. This is what they'll be cleaned with. This is the frequency with which they'll be cleaned. These are the products we use. We've stockpiled products to last us for a period of time. I said, great, I'm really glad to know that. But as we have more people back in the office and more people touching surfaces that are very regularly being disinfected, are we worried at all about the residue? What's our approach on that? And that caused our office services manager to go in and to find that there is actual OSHA ratings on products as to their toxicity and the level of residue they leave behind, and to examine. And we found that many of the products we were using are fantastic, and some others have a very high toxicity residue. And in order to keep our employees safe and happy and to avoid potential liability down the line, we've decided to add an extra step, which is to wipe down with clean water and a paper towel any surfaces after they're disinfected to make sure that we don't leave a lot of residue. Those kinds of thought processes in advance, talking through with your team to make sure you're making the right decisions, I think are a really great opportunity to make sure that your people have tremendous confidence in what you've set up. Masks are another issue. For any of you that are thinking about requiring masks, as Cass will tell you, well, then does it become an employer obligation to make sure they're available? And if you do want to be ordering masks, the lead time right now is rather significant. We had ordered masks from our distributor, and those masks came into the country and they were seized by the United States, which used them for other higher priority uses. And unfortunately, that left us without a source. So we've had to scramble and get other sources. But one thing we did is we had a staff member whose job had been significantly reduced by working at home, and she sews, and she said she'd like to make masks for us. So during her workday, some days, she's making masks that we can provide to our employees. You need to think about things like rearranging your rooms. Are your conference rooms set up to really encourage proper social distancing? Should you take out half the chairs that are around a table so that you don't inadvertently have people sitting too close together? What about your break rooms? How are they set up? Are they being disinfected? Are people going to be sitting in the break room? Can we encourage people to be spending time outside instead of being in that work environment? So my hope is that some of this has been helpful to you and at least stirring some thoughts in your head about how best to handle the idea of bringing people back to work. Certainly, to the extent that your business can survive remotely for a longer period of time, I do think that's probably the best course. To the extent that people need to come back into the office, you have some very practical issues to think about, such as purchasing masks and disinfecting. And then you also have the legal issues to think about that Cass Fernie is going to talk to you about. So I appreciate the chance to chat with you all today. I'll be sticking around for the entire hour. And at the end, I think Jamie and I may also have a bit of a discussion about the PPP loans and the necessity requirement. But for now, I think I'm going to turn it over to Cass, and I'm going to go back on mute.
Hey, thanks, Scott. So that was so interesting because listening to Scott, which is something I do on almost a daily basis these days, um, it it really, I think that he mentioned are the practical aspects of the HR legal considerations that I'm going to talk about, and that's how it is in real life, and I guess that's how it is in webinars too. So I'm an employment lawyer. I primarily counsel and defend employers, and there's a lot going on this week. So we're going to talk about that. My questions should be on your screen, and they kind of segue from what Scott just talked about. And so my very first question was, what do you do if an employee refuses to return to work because of a fear of contracting the virus. And the first thing that you should do is have a conversation with the employee to figure out what's going on. Under OSHA guidelines, an employee can refuse to work if they reasonably believe that they're in imminent danger. And in past webinars, we've discussed this imminent danger thing. And, imminent danger is immediate. And you think, oh, they're going to be seriously harmed or die or whatever, and it's fairly immediate. But some changes in the law that we're going to talk about have kind of made imminence and dangers in the workplace something that is a little less, well, I guess a little bit more defined, actually. And that is with the governor's new order regarding workers' comp that I'm going to get to. But back to your conversation with your employee. You need to determine whether or not they reasonably believe there's an imminent danger, and reasonable belief is based on a fact. It's not based on, I'm freaking out because, of some imaginary thing or anything like that. Most likely, in most circumstances, it's going to be based on either some physical issue that the employee has or some engineering problem in your workspace. So let's talk first about the employee's physical issue. And this kind of segues to a question we've been asked in the chat, which is, can you tell older at-risk employees that they have to work at home until notified otherwise? So I think this is going to speak to that. So if you have an employee that is a high risk, maybe they have respiratory disease or diabetes or one of those things that the CDC has said places you at a higher risk, you need to have a talk with that employee about risk. You don't need to ask them what's wrong with them. You need to tell them and make sure they know about their ability to take leave, their ability to talk to their doctor, what kind of leaves you offer. And a lot of that's going to be in your employee handbook. And you need to go down kind of a reasonable accommodation road because they have a physical problem that may make them more susceptible. So you just need to treat that as you would any employee that has a physical problem that makes them particularly susceptible. Have a conversation with them and see how you can accommodate that. The second possibility is that there's something in your environment that is creating the fear in your employee. Under the OSHA regulations, employers are required to assess and correct hazards in the workplace. And I think that over the course of the last 2 months, we're all coming to the conclusion that COVID-19 may be a hazard. And so if it's in your workplace, it is potentially a hazard in your workplace. And so what your employee may be telling you is, hey, I can't sit, shoulder to shoulder with Bob anymore. I need to sit, 6 feet away from Bob or whatever the case may be. And they may be telling you about something you can fix in your working environment that will make them feel safer. And this conversation and these measures that you take are going to head off your employees' fears by demonstrating that you're listening to them. You have measures in place to create a safe environment. And I'm going to talk about more specific measures on my third question. But the other thing you need to do when you deal with your employees in this fashion is to document your efforts with them. Make sure, like you always would, that you are documenting it on the personnel side if you're having a reasonable accommodation type discussion, and document it on the OSHA side if you're having a safety discussion. Say, oh, we moved the employees 6 feet apart, because that's going to make it look like you are playing ball with all the new requirements. And that leads me to the next big issue, which is a little bit of a segue out of what I was going to talk about. But there was a new executive order that the governor issued on May 6th, which was Wednesday, regarding workers' comp. And this is super important because basically the governor's executive order says that any COVID illness of an employee is going to be presumed to arise in the course and scope of employment if certain requirements are met. This is important. A presumption that it arises in the employment means that it is going to be the employer's burden to show that it did not arise in the course of the employment. And this is really a big deal because, as a general matter, people go out and about, do their thing. They may come into work, they may go to the grocery store, they may go to a rally on the steps of the Capitol. And if they do all three of those things, right now, the presumption is going to be that they caught it at work. And so that's a big change, and that's a big deal. And so you're going to get this presumption if the employee tested positive within 14 days after performing labor at the place of employment and at the employer's direction. So at the employer's direction is something that you can control. And if you've got people teleworking, then this sort of thing means that maybe you should keep them teleworking. The other thing about this is that it's going to be retroactive. This goes back to a day of labor performed on or after March 19th. So you can go back into your mind in the Wayback Machine and remember what you were doing on March 19th and whether your workplace was even evacuated at that point. So that's kind of a big deal too. The order will remain in effect until July 5th. So from March 19th to July 5th, this is the state of affairs with workers' comp. The other really interesting thing about this order is that the place of labor that we've been talking about is not the employee's residence. So yet a boon to telecommuting. So it's kind of fun. On the one hand, these are steps to go back to work, yet on the other hand, we've got this presumption in the workers' comp forum that may make employers think twice about refilling their office. So with respect to that executive order, if it's possible, keep your telework in place if you're doing that. Make it the employee's choice to enter the facility. Always, always, always keep sick people out. Tell them to go home. Don't let them come to work. And document everything you do to make your workplace safe. So my next question is, what policies need to be updated to get people going back to work? And so, you know, there's a ton of policies that need to be updated. You need to look at hiring stuff. You need to look at whether remote interviews are something that you're doing now. What are your staffing needs? Make sure that you look at your leave policies. How do they intersect with the new laws, the FFCRA? How does that play in? And do your employees understand these policies? Is there something that explains them in writing? Look at your telework and childcare options. Look at your options for rehire and reinstatement. What's your employee assistance program? Do you have one? Make sure your employees know that. Communicate with them regarding expected return to work deadlines. But primarily, the policy that I'm most concerned about today, that I'm going to talk to you about, is your injury and illness prevention policy, which is your IIPP. Because this policy really dovetails with the stuff that Scott mentioned, the new California state guidance that came out yesterday, and there's another anticipated executive order that's supposed to come out today. I would have bet money that it was going to come out at 11:59 right before this talk, but So far, it hasn't come out yet that I've seen, but it's supposed to be out sometime today. So the injury and illness prevention policy, which I'm going to call an IIPP, that's how it's usually referred. Uh, the IIPP needs to address in writing um, identifying new or previously unrecognized hazards. It needs to address training on those hazards, and it needs to address documentation regarding both the training and the hazards. And as I said, I think we all can look at COVID-19 as a hazard, particularly in light of the new workers' comp order that just came out. So I'm going to talk a little bit about safety stuff that you've been hearing from me, and if you've been listening to our webinars from Liz Stallard, probably for the last month or so, but you're going to hear some of it again. And when I talk about the state guidance today, you should be thinking in your mind about updating your IIPP. You need to take the steps in the state guidance. You need to document that you're taking the steps in the state guidance. You need to train your employees on these steps before you have significant numbers of people come back into your workplace. You need to document your training. So sign-in sheets, dates of training, if you're using PowerPoints, all of that kind of stuff. And you need to continually inspect your workplace as people come back into it to ensure that your steps that you're taking to make the place safer are, number one, working, number two, being followed. These steps are going to insulate you with respect to that presumption of COVID-19 in the workers' comp law, right? That's a rebuttable presumption. So it's your burden to rebut that. And by having writings and plans and trainings at your fingertips, you can demonstrate, hey, I put every single employee into an enclosed bubble and they came into no contact with anything else in the workplace. And I just had to say that because I'm going to date myself now. There used to be an after-school special about a boy that was in a bubble. And so every time I think about this, I always think about the boy in the bubble. But obviously, you're not going to put your employees into a big bubble, but you're going to come as close to that as you can if you want to, within reason, within practical boundaries, just make your workspace as safe as you possibly can. Demonstrate both to the state of California, but also to your fearful employees that you are doing everything that you can to keep them safe. So I'm not going to get deeply into the state guidance, but I am going to tell you how you can get deeply into it. If you've got a pen, you might take this down. The website is covid19.ca.gov/roadmap/. And this is on the governor's website. You can also get to it if you go on the governor's website, go to newsroom, go to updated industry guidance, click here to see the new guidance. It's a little bit unwieldy to get to, but you can get to it. But if you follow the link that I just gave you, that'll get you there. So the governor has this whole plan about that I think Scott mentioned about phase 1, 2, 3, 4. And it also has 17 different industries listed. And there is separate guidance for each of those 17 different industries. So obviously I'm not going to go there because I don't have the time, and neither do you. But you can go check out your industry. What you'll find is a very detailed guidance document, and you will also find a checklist document. And these documents will tell you how to make your workplace safe, and it actually dovetails what you should be doing with your IIPP. And so it actually all comes together in a very nice harmonious way for you because it just lays it out. These are the standards the governor's setting. And if somebody says that your workplace is unsafe, but you are complying with the guidelines set forth in these state of California standards, it's going to be difficult to say that you were somehow creating an unsafe space for your employees. So the checklist is pretty cool. And I'm going to talk just a little bit about the one for office work because uh, I work in an office, and because I think a lot of you work in an office. But there's specific ones for grocery and all of that. So go there and look if you're not in an office. But actually, I think most people have an office of some kind. In any event, so the office guidance requires a written worksite specific plan. It requires employee training. It requires control measures and screening. It requires cleaning, and it talks about distancing, and it gives details in all those areas. So if you create the written plan suggested by this website, it can be part of your IIPP, and you kill two birds with one stone. I'm not going to go into great detail because Scott kind of did on, clean the workspace, but there was a couple things I thought were really interesting. Scott mentioned masks, and I thought the stuff about masks was stuff I didn't really think that you would need to tell someone, like don't share your mask with other employees. That's kind of I don't know, not something that I would do, but probably there are people that might do that. So you should tell your employees not to do that. The other things that you should tell your employees about masks are that they're not PPE. They are not considered PPE if you're wearing these cloth masks. Um, you should wash the masks daily. You should keep your hands clean before adjusting your mask. You should not let the mask make you touch your face more often than you ordinarily would, which is, hard enough not to touch your face all the time, but then put a mask on it and try not to touch it. So just remind your employees of all that kind of stuff. Another interesting item that I liked in the office guidance was it talks about elevator etiquette. I don't know how many of you have been to the office since this has started, but it does create an awkward elevator situation when there are a number of people all waiting for an elevator. And I think a little bit of office elevator etiquette has already evolved because people are willing to take other elevators or wait for the next elevator. That may change, though, as the workplace fills. So be sure that you pay some attention to elevator etiquette. So that's all I really have to say. I urge you to check out the governor's website, look for your industry, let that be your guide in what you're going to do. And I'm going to stop talking and let Kristen start talking now.
Thanks, Cass. Hi, everyone. I'm Kristen Caprito. I'm an estate planner here at the firm. I think it probably goes without saying that most people are trying to find a way to feel empowered in an environment where most of us don't have any control right now, and getting their affairs in order is probably one of the ways I think people are doing that. That in combination with a whole lot of time, it's either clean your garage or get your trust together. And so we're seeing a pretty big uptick in estate planning right now. Some of the issues that we're having is meeting with clients. How do we do that? Where do we do that? Are our employees safe? Are we safe? Are our clients safe? A lot of our clients live in facilities and we can't actually get to them. I'm meeting with a woman next week where I will be hollering at her through a glass window at her care facility while standing on her patio to find out what her wishes are with respect to changing her trust. So kind of a lot of strange logistical hurdles that we're experiencing now in a way that we haven't before. But since we're talking about employee and employer issues today, I thought it would be good to kind of give employers some tips on how they can make their employees feel a little more safe and secure when they do come back to work, knowing that their loved ones would be cared for. Asking folks to revisit their beneficiary designations on their retirement accounts and their life insurance. This can be a very, very simple way to, one, avoid any sort of a probate when somebody passes away. Probate in California is required if your assets that otherwise aren't disposed of in a trust or a beneficiary designation if they exceed $166,250. And so by either jointly titling accounts so that there is a pay on death beneficiary for a bank account, a retirement account, or a life insurance policy, in addition to jointly holding title to real property. That's one way folks can avoid probate without being required to potentially see a lawyer. Of course, as Jamie said at the beginning of all of this, each situation is different. So it might be worth speaking to a lawyer about, you know, what your goals actually are before running out and retitling bank accounts. But as far as employers go, really kind of asking your employees to revisit those designations on the retirement and the life insurance, it can go a long way. I meet with a lot of clients when I ask about beneficiary designations who really have no idea who their designated beneficiaries are on their retirement or their life insurance. So always nice to kind of give folks a gentle reminder to look at who those people are and who they have named there. Some of the other things employers can do, and we have some links on our website, is to provide their employees with access to free estate planning resources. The Sac County Law Library has a bunch of free forms on their website, including statutory wills, statutory powers of attorney. Most major healthcare providers have links on their websites to statutory advanced healthcare directives and HIPAA waivers. And so kind of directing your employees to those resources to make sure that they have picked the people who would make medical decisions for them in the event they can't make them for themselves is one way to kind of reduce that stress of the unknown if something happens to them. In that same vein, they can nominate guardians for their minor children in statutory will forms. And again, those resources are free on Kaiser, Mercy, Dignity websites, as well as the Sac County Law Library. Another way I think that employers can be really helpful right now to their employees is to kind of be ready to provide FMLA resources and disability resources, right? So if somebody gets sick, they need to take time to care for a loved one, or they themselves are sick and can't return to work. How do we deal with that? So kind of having the forms for that, the process for that ready kind of at the trigger if they're needed, and to be able to provide them to your employees remotely would not be a bad idea, because the last thing you would want is a sick person coming to your HR department and asking for the forms for disability to fill them out and to process those. Another aspect I think you could probably look at is encouraging folks to potentially revisit supplemental insurance. Companies like Aflac exist for a reason. So in the event they're sick for 2 weeks, and maybe it's not a sufficient amount of time to need to apply for disability or short-term leave or FMLA if they're caring for a loved one, Aflac and those sorts of supplemental insurance companies can kick in and help cover lost wages. I'm guessing those policies are fairly expensive at this point, but it still might be worth your HR departments looking into and getting those resources to your employees fairly quickly if that were the case. In a more meaningful, kind of mindful way, we're all very stressed right now. I have been on the receiving end of lots of panicked and anxious clients needing their documents now because we're all kind of scared and facing our mobility in the face. So remind your employees if they are working from home to take walks, to take the time that they need. Maybe small things like sending out tips on how to keep kids engaged if they are working from home. Remember that kids may be going back to school sooner than usual, which could always increase the risk of infection. And so I think everything that's occurred in the last 2 months has, I think, better prepared us for what may occur in the event that there's another spread, which we all believe and know that there will likely be. And so really using the next few months before that actually, or probably, will happen to be better prepared next time is always a good thing. Beyond that, I don't know if I have much more to offer.
Hey, I have a question for you, Kristen. So not to put you on the spot, but how are you or your department and the paralegals dealing with notarizing documents? Because your group probably notarizes more documents than any other. So there may have been some recent judicial council or governor's orders about notarization requirements. Can you do it remotely? What are you guys doing?
There actually has not been a whole lot of guidance on that. We were waiting for a pretty tense couple weeks thinking that there might be. Secretary of State is kind of the governing body that manages notaries, and California, after all the real estate fraud that was happening before the crash, is not kind of locked down on notary rules, so we're not allowed to do remote notaries. Other states allow for it, so the workaround some of us have been using is to hook clients up with remote notaries who can notarize their documents via Zoom or FaceTime, because California is required to take an out-of-state notary acknowledgement. They then get the documents to us. I think there will probably be an uptick in some litigation about some of these documents. I myself have masked up and gone to parking lots to meet clients. I know of other colleagues who are going to hospitals to sign documents with their doctor clients on hoods of cars, trunks of cars. My paralegal has actually gone to somebody's home and stood on her front lawn and watched her execute documents with the front door open from about 30 feet away. Ran up, left the book on the doorstep. The client ran up, gave her thumbprint, signed it. Everybody had their own pen. They never came within 15 feet of each other. And actually she took her daughter with her to witness the will, because wills take two witnesses who are not related to you and or interested in the will, meaning listed in the will. So there are some hurdles, but healthcare directives can actually be witnessed by two people as long as they're not people who are named in that document as an agent. So there's some workaround to notary rules. We're anticipating there will likely be more guidance in the next several months, and hopefully California will start allowing remote notaries.
Okay, thank you, Kristen. Again, my name is Jamie Dreher. I'm a partner in the firm's financial restructuring and commercial law group. I am primarily a bankruptcy lawyer. I also engage in commercial loan documentation, enforcement, and defense, which is going to be part of one of my topics today. And so we thought in advance, not necessarily because any of you on the line asked the question, but I'm going to talk a little bit about what's happening now in my world and in my environment, and to the extent you have questions about it, I hope the discussion's a little bit helpful. Kristen mentioned in her talk something, I think she used the words real estate crash. Well, this is not a real estate crash, and there's been not a total crash of the economy yet, but it's troubled. And there's trouble on the horizon, not to put fear into anybody's hearts or minds, but more so to be aware and to try to get ahead of things. So one of my broad topics, what's up on the slide? How do I negotiate a workout with my lender or borrower? So in looking at the attendance or sign-up list for today, it looks like for the most part, you all would fall under the borrower umbrella. So I'll kind of focus the discussion coming from that perspective. It looks like there might be some lender clients on the line, but I don't see any banks. So workout and loan workout is really just a generic term of art that doesn't mean anything other than borrower and lender are restructuring their formal relationship. So I'm going to give you what really is kind of a soft analysis of some issues and then just highlight a few things for you. First of all, if you're a borrower and you're in default under your applicable loan documents, which is what we're talking about, I'm going to kind of focus on loans, but some of these principles also apply to the real estate world and working out lease amendments and other types of and other related real estate documents. First of all, full and open and prompt communication is key. If you're a borrower or in the real estate world, a tenant, being in touch with the person you have obligations to in advance of a problem really sets the tone for the discussion that you are about to have with that contract counterparty. You know, and in my mind, the better relationship, the better. And what lenders do appreciate is prompt, full, and open communication. So that means a couple of different things. It means, one, don't wait until you miss the first payment to notify the lender there's a problem. They'll know that. Notify them in advance, and at least let them know what you're facing. In this current environment, they will work with you. A couple of other things. You need to have your financial and your accounting processes and structure in order, meaning you have to be able to produce for your lender or contract counterparty or landlord accurate, full, and complete financials. So if you're falling behind in that regard, if you've had trouble in that regard, before you approach your lender, get that in order, whether it means hiring additional help or a professional to do that, or doubling down internally on making sure that your financials are together. And all I really mean by that is having full documentation, having your general ledger up to date, to the extent you do quarterly audits or something along those lines, having them done. So have your financials in order, have projections prepared to discuss with your lender. I will tell you that as a borrower, when you approach a lender, let them know you're facing a problem, they're going to want to know a bunch of different things. They're going to want to know, why did this happen? How are you going to fix it? And what's best for me, meaning the lender. So two of three of those things are under your control at the outset, which is, why did this happen? The explanation. How are you going to get out of this? Meaning the projection and the plan. Yes, there's economic uncertainty, I think, for everybody right now. But at least having a logical kind of factual outline of a projection that has some kind of basis in fact is going to be helpful. And the third part is what's in the best interest of the lender. In order to negotiate a workout and the document by which that is embodied is either maybe a forbearance agreement to a loan document or an amendment, depending on what the terms are, which could be any. You need to know where the lender is coming from. I mean, right now, lenders are willing to listen. Lenders are healthy. Lenders' balance sheets are healthy. That may change soon. You need to know where they're coming from and what their interests are. Another aspect to that is, and I'll just segue quickly to move into the bankruptcy component, just so I have enough time, is what is the best result for me as a lender? For most operating businesses, is if you're bringing in revenue, you've got customers, you've got clients, you've got sales, whatever the case may be, it is most often in the lender's best interest to keep the business alive and keep that revenue generating as long as they see a plan. The plan meaning, where am I going to get my new revenue stream from? How am I going to reduce expenses and things like that? So you need to make a case to the lender why it is in their best interest to help you and keep you in business. The lender is going to be looking at that and making a determination, at least on that outward-looking basis, whether it is in their best interest to exercise their rights in a default and potentially put you out of business, or to keep you in business under a restructured arrangement. Internally, inward-facing from the lender's perspective, and unfortunately to you borrowers out there, the success of a workout negotiation or not often depends on things that you will never know about and things that are completely out of your control. For example, the personality of the loan officer at the bank, the the malleability of a special assets officer, what the bank's internal balance sheet looks like, what their reporting of bad loans looks like internally, whether they have quarterly or monthly metrics they're trying to hit on their balance sheet. Those are things you probably will never know. It's good to gather as much information as possible for yourself because that kind of guides what your offer is going to be, what your options are. From a lender's perspective, trying to figure out what their needs are, one, you ask them and see if they will tell you. Two, as of May 7th, it looks like the FDIC published has a frequently asked questions for financial institutions affected by coronavirus fact sheet at fdic.gov, which is a 25-page document with FAQs for regulated lenders, including such things with questions like, as a regulated lender, are we able to offer accommodations to borrowers? What does our credit reporting have to be? How do we have to report these delinquent loans? They have to be reported as troubled debt restructurings or some other thing, and how does this all work? Well, those are all kind of very complicated regulatory issues for lenders, but guess what? As a borrower, if you know the answers to those questions, you can guide them and help them help yourself. So in a loan workout, full open communication, get your financials in order, approach your lender sooner rather than later. Lender's going to ask you probably to enter into a pre-negotiation agreement that basically just allows the lender to reserve their rights to assert defaults and enforce them. At some point, the lender's also going to ask the borrower for a release of any lender liability claims, which is important to them. From a borrower's perspective, unless you're really aware of some inappropriate action the lender's taken toward you, there aren't too many circumstances under which you should object to that. And then the change in terms of your financial relationship with your lender is documented through a loan forbearance agreement where the lender agrees to forbear from enforcing rights, or through an amendment to the documents, and it could, whether a lease document or a loan document. And really, the options are limitless. Change in terms, change in maturity date, change in interest rate, deferred payments with some payments recapitulated over time, an agreement to sell a certain asset by a date certain, the addition of collateral. All those are types of things that are all up for discussion, and really kind of the creativity of yourself and your advisors is what's going to form, and then also, of course, the lender's response, what that document and renegotiated agreement looks like. So that's real kind of general on loan workouts. I do want to talk a little bit about some bankruptcy basics. I don't have too much time, but for those who might be interested, a little bit of background on bankruptcy. One of the effects of a bankruptcy filing by a company is obtaining the benefit of what's called the automatic stay, which you may have heard of. The automatic stay is, I describe as a kind of like automatic worldwide injunction preventing anybody, any creditor, any plaintiff, any contract counterparty, subject to some exceptions, from filing a lawsuit, continuing litigation, collecting invoices, enforcing loan defaults. It's this injunction that is one of the great benefits to filing a bankruptcy case. So you can imagine if you're facing claims from creditors or lenders enforcing default rights, that is one of the main reasons companies file bankruptcy, is to obtain the benefit of the automatic stay. There are probably 4 applicable chapters of the Bankruptcy Code, which is Title 11 of the United States Code, that you might be interested in or have heard about, and I'll just give you a few second rundown on each of those. One is Chapter 7, you may have heard of. In a Chapter 7 bankruptcy, a company initiates the case by filing a petition and a statement of financial affairs, which are fairly comprehensive documents that outline all of the assets, liabilities, and financial history of the entity. And on the filing of the case, an independent third-party fiduciary is appointed, who's called a Chapter 7 trustee. Mainly, they are accountants or lawyers, and it is their job to liquidate the assets of the debtor as of the filing, and if there's any assets available, which could be receivables, selling personal and real property, filing claims against third parties and the like, then those funds get parsed out to creditors. Businesses generally cannot operate in a Chapter 7, and most trustees will not operate in a Chapter 7. So if you're going out of business, the Chapter 7 bankruptcy might be your option. There's a few more details in there about whether or not it's advisable in a shutdown situation that I keep in mind. I probably don't have time to address now. What you've definitely heard about in the news is Chapter 11. Chapter 11 is most often referred to as the reorganization provision of the bankruptcy code. Chapter 11 allows a company to continue to operate in the ordinary course, provides a mechanism by which all debts that are due as of the petition date can later be structured and paid over time, and some other things. It's a fairly complicated court-overseen process that is a little bit expensive. Under the right circumstances, though, it can really save a company. From an operating company's perspective, as long as you're generating revenue and or have cash, from a real estate perspective, as long as the property has some equity. It looks like there's some folks in the ag business on the line. There is a Chapter 12 of the Bankruptcy Code, which is what's called for family farmers, which is very broadly defined as somebody involved in generating revenue in the ag industry, including landowners. And it is a very much easier process and therefore less expensive to navigate than Chapter 11, very friendly to farming concerns in the sense of what's required, what the filing requirements are, what the reporting requirements are, and how easy and difficult it is to confirm a plan. Chapter 12 used to be somewhat restrictive because there's a debt limitation that was in the couple $1 million range. Last year, the debt limitation for Chapter 12 was raised to $10 million. So really it's focused on what's supposed to be focused on what's called the family farmer, not larger ag concerns. So if you are in the agriculture industry and your debts are less than $10 million, Chapter 12 is a very attractive option. Just this year, actually in February, a whole additional separate and brand new subdivision of Chapter 11 was enacted, which is called Chapter 5 of Chapter 11. And originally, up until I think last month, the debt limitation on new Subchapter 5, Chapter 11s was $2.7 million. It was just increased just for the next year in the current environment to $7.5 million. So if you were an individual or an entity with debts up to $7.5 million right now, and you wouldn't otherwise qualify for a Chapter 12, then you could take advantage of the new Subchapter 5 of Chapter 11, which again is a very truncated process. The filing requirements and plan confirmation requirements are much less onerous and could end up costing a third of what a full-blown Chapter 11 would cost. Just based on time, I apologize, I've kind of run out, and so I'm just going to stop talking about bankruptcy. Scott Shapiro, are you still on the line? We wanted to just talk briefly about the necessity requirement, certification requirement of the PPP loans people have been talking about in the past week, and Scott and I had a discussion about this morning. Scott, are you there? Do you want to kind of frame the issue?
Sure. Yes. Thanks, Jamie. I am here, and we can do this quickly because I suspect many people on the phone have taken advantage of or are thinking of taking advantage of the payroll protection program loans that are out there. And you've probably all been reading stories. Certainly the Sacramento Business Journal has covered it extensively about it may be easy to get the loans, but how easy is it to get the loan forgiven? And one of the questions that's out there right now is, was the loan necessary for your business? Because it must be necessary in order for it to be forgiven. And so Jamie and I thought we might just take a minute and talk with you a little bit about what's going on in that. And I'll just start by noting that if at the end of your analysis you conclude that it's not necessary or you're not willing to take the risk, the SBA just set next Thursday, the 14th, as the new deadline to return the money and not have to pay interest or any potential penalties if you conclude that you should not have taken it in the first place. So that's, I guess, the one deadline as attorneys would want you to be aware of. Having said that, I think Jamie and I are pretty much in agreement that this may be a bit of a tempest in a teapot. And Jamie, I'll turn it back to you maybe to start the discussion.
Well, just kind of two quick elements. One is the necessity requirement is one caveat to that is the necessity can arise out of economic uncertainty. So it doesn't necessarily mean that you have to have the money in your bank account because you don't have a dollar to make payroll. But an alternative is that the current economic environment makes you believe it's necessary. So that's just a little caveat there. I have to say that in talking to a handful of clients this week about this very issue, almost everybody's facing economic uncertainty. So depending on what type of organization you are, obviously the size and things like that, for a smaller organization, I'm not really seeing any issues. I mean, the things you've been reading about in the news are large public companies with large, access to capital, feeling the heat a little bit on that. And that raises the only other point I wanted to bring up, which is one of the factors that Treasury has outlined in its FAQs and what people are talking about is the access to other liquidity. That can go a couple of different ways. Just because you have availability on your line of credit doesn't mean you can't take a PPP loan, but it is something that has to be taken into consideration. So those are all my two comments on that. Scott, did you want to finish up or leave it there?
Yeah, thanks, Jamie. So I guess what I would finish it up with is there are a few things that make attorneys good. Obviously, understanding the law and being good strategists is important. Another thing is knowing how to frame a story. And what each of you can do as you consider your loan and as you make sure that if you are audited, if people ask questions, what is your story? Do you have evidence that revenues have been down as a result of COVID-19? Do you have competitors that have chosen to lay people off or furlough people? Remembering the purpose of the PPP loan is to keep people employed. What have you documented about those issues? What major clients or customers or receivables do you have that are getting delayed? The more you document those things now at the time of taking the loan, the more relevant that information will be for you to tell your story if you're ever questioned about it. And so I guess what I would leave you with is the analysis that Jamie provided, which I agree with 100%. And the other is take a few minutes to set a few pieces of paper aside in that file now. So if this comes up a year or a year and a half from now, you're not having to try to go back and figure that all out. So Jamie, I'll hand it back to you and Mary to finish us out.
Thanks, Scott. We're going to end there, and we appreciate everybody participating and calling in, and we'll let you get back to business or pleasure or whatever it is you're up to. I would just mention that this webinar was recorded. It will be available on our website at www.downeybrands.com. Probably it'll get up there Monday.
By Monday.
By Monday, we think, and there's some other resources there in support of our discussion if you want to take a look through those. We appreciate it. So thanks, everybody.